The fight over the future of suppressors and short-barreled rifles just got even bigger. Not only did the federal court that is handling the silencer shop NFA challenge just schedule oral arguments that will happen next week, and he actually revealed the exact constitutional questions that he wants answered during those arguments. But now a second major NFA challenge has also been consolidated into that very case and will be heard at the same time. But this really is just the tip of the iceberg. The big news right now is that the plaintiffs in these cases have dropped a new bomb on this court, and they submitted a notice of supplemental authorities revealing 3 brand new Supreme Court rulings that fundamentally alter this case and deal a very critical blow to the NFA going forward. Not only do these 3 new Supreme Court rulings instruct courts on exactly how the Bruen 2A analysis must be performed going forward, but they also completely wipe out some of the government's favorite and major arguments and defenses in this case. This will now all come to a head next week during the scheduled oral arguments in these cases. So let's break down what exactly is now happening. Now, if you like this type of content and you want to ensure that you get updates on these NFA challenges going forward, make sure you like, comment, and subscribe, and turn on all notifications to ensure you get these updates when I release them. Now, if you've been following this channel, you will know that this all really started after Congress passed the One Big Beautiful Bill, which effectively zeroed out the NFA making and transfer taxes on suppressors and SBRs, and it took it from $200 to $0, and that's what we currently have. Now, historically, the Supreme Court upheld the NFA strictly as an exercise of Congress's taxing powers. But if the tax is now $0, the question is, can the federal government still require registration, fingerprints, and also put in place felony penalties? That exact question is now being litigated in a federal court in Texas, where the silencer shop case and the Jensen case have now been combined and consolidated before a single judge in that court, and it's going to be argued in front of that judge next week. But now something else has developed in this case. The Jensen plaintiffs just filed a formal notice with the court, and they pointed to 3 landmark Supreme Court rulings that came down just this term at the end of June. These cases are the U.S. versus Hamani case, the Wolford versus Lopez case, and then also the Landor versus Louisiana Department of Corrections. The plaintiffs are using these 3 cases to systematically dismantle every single defense that the DOJ and the ATF have been trying to use in this case to save the NFA. So here is how these new decisions are completely changing the game here when it comes to the NFA, and here's how the plaintiffs are trying to use this to dismantle the NFA as it currently stands. The plaintiffs here point to the Landor case because, as we've discussed, the DOJ's newest defense is that even if the making and transfer taxes are currently 0, the registration system, they argue, is still constitutional because it helps to enforce the special occupational tax, which is paid by NFA businesses. The plaintiffs here point to that new Supreme Court Landor case in that ruling to shut down that argument. Now, Landor explicitly limits Congress's spending and taxing powers, ruling that they cannot be stretched to drastically expand federal authority. The plaintiffs argue that under Landor, forcing a burdensome registration scheme onto everyday untaxed Americans is just to support an occupational tax on businesses is essentially a massive unconstitutional expansion of Congress's powers. So in short, they argue that no tax, no registration powers, and that must be done away with. Now, the second case they point to is the landmark 2A case that we just got, which is the Wolford versus Lopez case. And that was a massive victory for the Second Amendment, once again striking down limits on concealed carry, and that did away with the vampire rule, essentially banning concealed carry holders, even if they had a permit, from carrying at certain locations that are open to the public because of these default laws that were put in place in states like Hawaii, California, and others. But the Wolford case was also a massive ruling because it once again reaffirmed the Bruen analysis and clarified it going forward for lower courts. The DOJ repeatedly tried to argue that suppressors and SBRs aren't even arms protected by the Second Amendment at all. But Wolford completely solidified the rules for Bruen and the current Bruen Step 1 process. The Supreme Court ruled that the only predicate question at the plain text stage, which is the first step, is essentially, does the law concern any form of arms? As the plaintiffs noted, a suppressed firearm or an SBR is undeniably a form of an arm, and regulate them plainly concerns the use of a firearm. Therefore, under Wolford, suppressors and SBRs are presumptively protected by the Second Amendment, and the entire burden then shifts to the government to prove that they are dangerous and unusual items and that they have a historical justification to support those types of restrictions, and that must be done at step 2. Now, even better, Woolford completely smashed a trap that anti-gun courts have been trying to use for years after Bruin. Lower courts essentially love to say that, well, you have to prove that a firearm is in common use before we even look at the Second Amendment analysis. The Supreme Court in Woolford explicitly stated that the in common use analysis is completely out of place at Bruin's first step. Justice Barrett even noted in her concurrence that the government cannot smuggle in regulatory limits into the plain text stage, which is the first step. This means that the court must start with the presumption that what you want to do with a firearm is in fact protected. Now, for a long time, the government has relied on a Fifth Circuit case called U.S. versus Peterson, and that argued that shall issue licensing and registration schemes get a free pass under Bruin and that scrutiny. And essentially, they've also applied that to the NFA in Peterson, saying that the NFA operates like a shall issue licensing scheme, and therefore it just automatically gets a free pass under Bruin. The plaintiffs here argue that the Woolford case completely obliterated that loophole. Woolford leaves absolutely no room or caveats, essentially reaffirming that there are strictly 2 steps to the analysis: the plain text step and then the historical inquiry. If a law impacts the plain text, it is presumptively unconstitutional, and that is period. It's presumptively unconstitutional. So the plaintiffs argue that the logic used by the Fifth Circuit in the Peterson case is currently invalid. It should have been invalid under Bruin, but even more so, it's invalid now under Woolford, and now that must be thrown away. Now, finally, the plaintiffs point to both the Woolford case, but also the U.S. versus Hamani case, where the Supreme Court kind of drew a line between licensing a person, giving a permit, and then also registering and tracking a gun. So in both cases, the Supreme Court analyzed the how and the why of these types of restrictions. So they said that licensing is about checking if a person is disqualified, where registration is about tracking the physical property. Because the how and why are completely different, the government cannot use historical licensing laws to justify the NFA's tracking and also the registration database. They are 2 different hows and whys. So stepping back, the Northern District of Texas right now is kind of the epicenter for challenges to the modern NFA as it stands after the $0 tax changes. One single federal court is now evaluating 2 critical cases. They're looking at the constitutionality of the NFA as it currently stands, and they're analyzing it not just under what is changed with the $0 tax process, but also these new Supreme Court rulings on 2-way cases. The judge and court here are actively also asking if the registration can survive without a tax. And now the Supreme Court has heavily also favored the plaintiffs with some of these new rulings, giving them additional ammunition to fight back against the NFA. So the upcoming oral arguments and decisions in these consolidated cases are looking more critical than really ever, and I will be following those arguments as they come up, as this develops more, and as we get the additional briefs and potentially even the order from the judge here. I'll be following that, and I will let you guys know as that happens. But again, there's a lot moving right now with some of these Supreme Court cases that recently happened, with some of these changes now in these cases, and also with the Supreme Court recently taking up the AR-15 hardware ban cases. I'm anticipating really there's going to be a lot of movement and a lot of changes on not just NFA questions, but a lot of other 2-way topics as well. So as it develops more, as we get more information, I will let you guys know. If you found this video helpful, make sure you subscribe and also turn on all notifications to ensure you get these types of updates when I release them. Also, let me know your thoughts down below in the comment section. Do you think the Supreme Court now with these new rulings has cleared up enough questions to where the courts here will rule against the NFA? Or do you think they will continue to rule in favor of the ATF and the federal government and keep these in place, keep the NFA in place, and still claim that it operates like a shall issue permit? Let me know your thoughts down below in the comment section. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.